So, how do we get rid of these amendments? Let's look at Article 5 of the Constitution. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to the Constitution or on the application of the legislatures of 2/3 of the several states. States can call for Congress to propose amendments to the Constitution. Shall a convention for proposing amendments which in either case, or the Congress shall call for a convention for proposing amendments which in either case shall be valid to all intents and purposes as part of the Constitution when ratified by the legislatures of 3/4 of the several states or by conventions in 3/4 thereof. I'm going to pause here for a moment and discuss this. I don't expect Congress to surrender this willingly. Ultimately, I think what the states are going to have to do is just 3/4 or 2/3 of us are just going to have to call for a constitutional convention. We're going to have to propose a very simple amendment, but basically just says we hereby repeal the 16th Amendment to the Constitution. Another says we hereby repeal the 17th Amendment of the Constitution. Just read the 21st, which repealed the 18th Amendment. That first clause, it should look like nothing more complex than that. And there's a lot of concerns about a constitutional convention that are floating around out there. I just want to address them up front. First of all, the 16th and 17th Amendment got passed without a constitutional convention. Congress can mess this stuff up without a constitutional convention anyway, so that concern is not legitimate. Secondly, we must consider that no matter what's proposed, 3/4 of the states must approve it. One argument's been made that the convention could theoretically propose could just basically change the entire Constitution, because that's what it did after the Articles of Confederation. That we called for the Constitutional Convention. We came out with a whole new Constitution. The problem with that argument is it still requires 3/4 of the states to agree. Last I checked, all 13 states eventually ratified the new Constitution, so that was 100% agreement in that particular case, or at least on a state-by-state basis. So I just think these arguments are worth at least addressing. I think it's the only way it's going to happen because Congress is not going to just simply surrender this power. I just don't think it's going to happen. I think the states are going to have to just take action. But is there a second path? Article 5 gives exemptions in the Constitution which cannot be amended. And Congress shall propose amendments to the Constitution and all that. So I've read through that. Provided that no amendment which shall be made prior to the year 1808 shall in any manner affect the first or fourth clauses of the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. Now, does that last statement apply only to 1808? Let's step back and read what Federalist Paper 42, James Madison, had to say about the 1808 clause. It were doubtless to be wished that the power of prohibiting the importation of slaves had not been postponed until the year 1808, or rather it had been suffered to have immediate operation, but it is not difficult to account either for this restriction on the general government or for the manner in which the whole clause is expressed. It ought to be considered as great point gained in favor of humanity that a period of 20 years may terminate forever within these states a traffic which has so long and so loudly upbraided the barbarism of modern policy, that within that period it will receive a considerable discouragement from the federal government and may be totally abolished by a concurrence of the few states which continue the unnatural traffic in the prohibitory example which has been given by so great a majority of the Union. Happy would it be for the unfortunate Africans if an equal prospect lay before them of being redeemed from the oppressions of the European brethren. One comment here, you think James Madison was for or against slavery. That's one argument against the Constitution I have heard on rare occasions from some critics out there, is that, well, it supported slavery. Well, very thinly it supported slavery. James Madison was clearly opposed to it, and this is really just about the only mention of it in the Constitution. Clause 1 of Article 1, Section 9 says, migration or importation of such persons as any of the states now exist shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation exceeding $10 for each person. No tax or duty shall be laid on the articles exported from any state. Clearly, the 1808 restriction applies only to slavery. Thus, the restriction on denying equal state suffrage in the Senate without its consent still stands. So is the 17th Amendment only valid so long as the state consents? Another good question to ask is, in other words, upon ratification of the 17th, is consent permanent? One argument that I've made in answer to this question is, well, isn't 3/4 of the approval of the states necessary for any amendment to the Constitution? And of course we just covered that part of Article 5, and the answer is yes. So why even include a clause saying, well, this is something that can't be amended unless 3/4 agree? No, this is something that can never be amended. Let's fix what we broke, all the way back to Melanchthon Smith's argument. We attribute a lot of our problems to defects in our Constitution, and that's not the case. We're breaking the Constitution by adding a lot of these amendments in. Many people want term limits. That's one of my arguments against term limits. Many people want to repeal life appointments of judges, and that's one of my arguments against that. We see the harm that the 16th and 17th Amendment did. The last thing we want to do is start unraveling the Constitution anymore. I will direct you to Federalist Paper 72 regarding term limits, and I believe 78 and 79 regarding life appointment of judges. That will answer these concerns in quite a bit more detail. I propose let's try 6 years without the 17th Amendment before we even come back to discussion about term limits. Anyway, let's take the lead here. The states can take the lead. States are the stakeholders. Should their legislatures refuse an attempt to retake power? Ultimately, we can just tell the states, look, this is a potential power grab for you. Take it. I'm not saying that that's necessarily a good thing in and of itself, because that's still government power. But at that point, what we're doing is we're pitting state power against federal power, and that's, again, another check and balance. The governor can put the issue in a national spotlight by inviting other governors to a convention to discuss the issue. Governors can ask the state legislatures to take up the issue. If governors refuse to help and legislators refuse to vote for the repeal of these amendments, then they will have to explain to their constituents why they are not voting for action to achieve state sovereignty. That's a very big issue. That argument would probably have a lot of clout with them. Any given state can assert its Article 5 right to equal suffrage without waiting for an amendment, because that cannot be amended away. If a governor is elected on this platform, voters add clout needed to start the process moving forward. Put the federal government on the defense for once. Last comment I want to make. The prophet Ezekiel faced apathy. In chapter 33, it's written, "Thou art unto them a very lovely song of one that hath a pleasant voice, and can play well on an instrument, for they hear thy words, but they do them not. I know these words are pleasant to many of you, I ask." For they hear thy words, but they do them not. I know a lot of my words are pleasant to many of you, but I ask, what are we going to do? Are we going to take action? And I hope to talk to y'all later. Goodbye, and God bless.